Okay, welcome everybody to this webinar that we're having today on children's rights to identity, selfhood, and international family law. We have some fantastic speakers with us today. I'm here to welcome you on behalf of Child Identity Protection. Just to let you know that if you have questions and answers, please feel free to add them in the question and answer box and direct who you would like the question to, who you would like to answer the question. Also, this webinar is being recorded, so if you will be able to look at it afterwards if you would like to. Also, we will add all the PowerPoint presentations on the webpage. So now it's my great honor to introduce you to Olga Kasova, a well-known international family law specialist, former CRC committee member, who will be moderating this webinar today. Over to you, Olga. Thank you for being with us today.
Thank you, Mia. Hello, everybody. I'm really very happy to participate in our webinar dedicated to the launch of the book Children Rights to Identity, Selfhood, and International Family Law with co-editors and also authors Marilyn Freeman and Nicola Taylor and other brilliant authors. Some of them are with us today and will share their thoughts on different aspects of children's right to identity. We all know that the Unconventional Rights of the Child is the very first human rights treaty that expressly recognized the child right to identity. Thus, as a legal concept, it is relatively new. However, it has a long history, and let me just remind you that psychologists were the first who raised concerns about child's identity as early as in the middle of the last century in the context of adoption secrecy, which was until recently an almost universal legal rule. They argued that adopted persons experienced severe psychological distress, which was not experienced, according to their findings, by children raised by their real parents. However, I should acknowledge that after the adoption of UNCRC, the Committee on the Rights of the Child didn't pay sufficient attention to the child right to identity. Exceptions were issues related to child nationality and child's name. CRC would start to address the identity issues in the context of adoption only in 2000, relatively recently. As for those issues that relate to assisted reproduction, the committee would start addressing them on a systematic basis approximately after 2013. The same relates, for instance, to baby boxes or baby hatches, whatever the term you prefer. Moreover, the UNCRC doesn't define the notion of identity, and doubts have been expressed whether such a definition is possible at all. That is not surprising to my view, due to complexity and ambiguousness of this term. The UNCRC Article 8 doesn't provide, as we know, doesn't provide an exhaustive list of elements of identity either. And indeed, it is hardly possible either, because almost all constituent parts of a child identity are in this way or that way relates to development of the child's personality. And in any case include cultural, social, religious, sexual, ethnic components, and probably many others. Thus, as the discussion today, I'm sure, will demonstrate, it is a complex and multifaceted concept. In my opinion, identity is about everything. It makes us who we are. Nowadays, fortunately, it is increasingly on the agenda and it is hard to overestimate the importance of the books that we are going to discuss today. It is, in fact, the very first publication that explicitly explores different dimensions of the child right to, of the notion of identity, first of all, and of the child's right to identity, and demonstrate the crucial importance of concept of identity for the child's development. Before I give the floor to our wonderful speakers, let me remind you about 2 points. First of all, while giving the floor to our dear speakers, I will not read their bios to save time. You may find everything on the CHIP webpage dedicated to the book and probably in the chat box. As the link will be in the chat box. And secondly, we will have time for questions at the very end. So please, as you have some questions, place them in the Q&A section box. So now our first speakers are Professor Marilyn Freeman from England, and Professor Nicola Taylor from New Zealand, co-editors, authors, and I believe the main driving force of this project. Welcome, the floor is yours. Thank you.
Thank you so much for the introduction. And I'm just waiting for Enola to, yes, start screen sharing. So here we are. Well, I do need first just to take a moment to thank Mia Danbach for her enthusiastic support for this project right from its inception through to her willingness to provide the insightful forward for the book, to arranging and to holding today's webinar launch. And all done, it must be said, with her extraordinarily high levels of efficiency and solidarity. And we are truly grateful, Mia, to you and to the CHIP team. And our thanks have to go to the authors, some of whom we're fortunate to have with us here today. They are a special bunch of skilled and knowledgeable professionals who shared our vision for this book and a readiness to embark on this journey with us. So we are deeply indebted to them, and also, of course, to the book's publishers, Edward Elgar, for their belief in this topic and in us. And we hope and trust that they will feel vindicated by what has been produced. And the us that I'm talking about in this expression of thanks is, of course, me and Professor Nicola Taylor, who will be speaking to you shortly, with whom I've co-edited this book, and we've co-authored 2 of the book's chapters. It has, as always, been a joy to work together. And we're separated by around 11,000 miles, but our trusty 24-hour clock has been put to good use as we have worked together to highlight the issues, and we believe produce a publication which does justice to its subject, and we hope that you will agree. So I'd like to just take a moment to first explain the reasons behind the book. Why this book? Well, we wanted to take an international and interdisciplinary approach to the transformations of children and young people, focusing on the synergies between historically unconnected areas of international law, some of which do fall squarely within the traditional boundaries of family law, but others which do not. And one such synergy or unifying perspective is identity and selfhood. And that's been largely unexplored in this context, but it provides an important lens through which these apparently unconnected limbs of international law can usefully be viewed. We think impact is critical to how people manage their lives after the events and the transformations that they experience. And we believe it is not enough to get through an event. We believe that for society to prosper, the well-being of its members is pivotal, and understanding and appreciating the effects of the event, particularly on identity, is a vital tool towards that aim. All the book's topics, therefore, which Nikki is going to be describing to you, are about children, young people, and families, and they are therefore either within the family law arena or closely related to it, so that we would argue, and do argue, that the family law principles and values could usefully be employed in these wider areas too. So greater awareness about identity and selfhood and the impact on them of transformations experienced by children and young people, and highlighting the way in which those transformations occur, both in core family law areas and in those which are closely related to them, together with a better understanding of the breadth which Olga has just described, the breadth of Article 8 of the UNCRC. This will mean that there's a greater likelihood that identity will receive the attention that it deserves and will no longer, as we argue, be a right hidden in plain sight. And we see this as having the potential to lead to a change in practice so that identity is factored into decision-making processes more explicitly. For example, as part of the best interest assessment or analysis in welfare decision-making, where that is pertinent, or outside of this, in whatever decision-making process is occurring where it's possible to do so. We also believe that this greater awareness has the potential to alter the way that we think about and teach family law and equip the lawyers of tomorrow, including but not exclusively family lawyers, because teaching is often the start of thinking, and it is thus an extremely important opportunity to affect future practice as it relates to identity. And all of this can positively influence the way that children and young people feel about themselves, their experiences, their lives, their place in society. In itself, we believe a very strong rationale for undertaking this project. Next slide, please. So here it is, the co-edited book, and the premise behind the book, the right to identity set out in Article 8 of the UNCRC, which applies, as you already know, in so many circumstances. The links between Article 8 and the other articles, in particular 3, 5, 7, 11, and 12. We've already, as I've said, we think that these are topics which are unarguably and inextricably connected to families. They look at domestic and cross-border contexts, and they look at how children's identity may need to be preserved or addressed. So next slide, please. Article 8, well known, I'm sure, to everybody. Here it is, just to have as a backdrop to our discussions. And of course, the background to Article 8, which I don't have time to go into now, but it is through the Argentinian delegation to the working group on the draft convention on the rights of the child. And it was in relation to very specific circumstances, which we just noted there at the bottom. And I won't go into the linked articles now, but I mentioned them. Article 3, best interests, primary consideration. Article 5, of course, evolving capacities. Article 7, the right to name and acquire a nationality. Article 11, taking measures to combat the illicit transfer and non-return of children abroad, which we think is really important to the fields of relocation, abduction, parental responsibility. Article 12, of course, the child capable of forming his or her own views. Next slide, please. So a broad scope to Article 8, but a narrow interpretation of it. And we would say that nationality, name, and family relations are just indicators of the aspects which are covered by Article 8, but certainly do not limit its scope. There has been no substantive comment on Article 8 by the CRC committee. And in the book, we have looked at, well, when I say we, one of our terrific authors has looked at the the practice, national legal practice in how Article 8 is determined, because it's largely determined by national legal practice. And she focused on a review of Dutch case law, finding that it's increasingly cited, but its scope appears too narrow. And even though we've had the recent 35th anniversary of the UNCRC, Article 8 is still in its infancy in terms of its development and application. And this is Soraya Bousvia, who said that similar conclusions are likely in other jurisdictions. It should be applied more often to optimize its development and benefit individual children. And I am going to hand over to Nikki now, who's going to look in more detail at identity, what it means, why it's important, the contents in the book, and what we are advocating in terms of change. So thank you all.
Thank you, Marilyn. And next slide, please. So what we are covering in the book, obviously going by the title, is around identity and selfhood. And we've just got these couple of quotes here from Charles Taylor, which are, in our view, oldies but goodies. So what I am as a self, my identity is essentially defined by the way things have significance for me. And what we particularly like in the second quote we've got from him is this idea of looking at identity as being a frame or a horizon from which I can try to determine from case to case what is good or valuable or what ought to be done or what I should endorse or oppose. In other words, it is a horizon within which I am capable of taking a stand. Next slide, please. One of the points that's made very strongly in the book, and I'm guessing that John Tobin may well be making this point again tonight, is the evolving nature of identity. So while our identity is initially attributed to us at birth by others in relation to our name, our history, our family history, etc., it's a concept that evolves over time. It's not static, it's shaped and developed by each of us throughout our lives in response to the experiences, relationships, changes and transitions that we experience. So a child's identity, like that of an adult's, is never completed, never finished, but is an ongoing process consisting of both static and dynamic dimensions. And that's partly why it's so critical that the law and international human rights is connected to this particular topic. Next slide, please. Identity can obviously be incredibly affected by the protective and risk factors that are influencing our lives. And so while protective factors can play a positive impact on our identity development, early life adversity and disruptive life experiences can very well interrupt or cause maladjustment in our identity development and lead to an unclear sense of one's own personal identity and the struggles that go along with that over the course of our lifetimes. So we're really wanting to emphasise in this book the importance of Article 8 and the protection provided by the Convention to minimise the detrimental impact of potentially negative external risk factors on children's identity. And because we're lawyers, Marilyn and I really want to also emphasise the importance of what family law and related fields can do to take better account of children's identity when they experience significant life-altering events and transformations. Next slide, please. So to give you a feel for some of these transformations and experiences that we've addressed in the book, and which, as Marilyn has said in her earlier presentation, relate to particular areas that are well known within the family law domain, but also some others that are not necessarily strictly conceived of as family law topics. We wanted to give you a bit of a sense of what the chapters in the book are about, and you're going to have 3 authors contributing their views on their chapters shortly. So firstly, Mia, we're grateful to you for writing the foreword and setting the context for the book. Marilyn and I then write chapter 1, which really tries to tease out what identity is all about, the rationale for the book, and what each of the chapters cover. and some of our views, which I'll talk about in a little minute, about unveiling family law and other related areas. You've already had a quote from Soroya in relation to the review of the Dutch case law. She completed her PhD on Article 8, and we were really, really fortunate that she was able to write one of the very early chapters in the book looking at the scope and potential for Article 8, which really sets a great framework for the rest of the book. Astrid is a psychologist in Cape Town, and she has written a chapter which really looks at identity from a psychological perspective, explains all those aspects to do with identity development and the concerns around disrupted or maladjusted identity for children. Two New Zealand authors, colleagues of mine, Trudy and Sarah Calvert, have written the chapter on cultural identity. And this is a fairly new concept in a sense, but one that we think is incredibly important, and we hope that other jurisdictions pick up on this as well. And then Fiona, and we've got Kathleen with us tonight, have written a really moving chapter about their experience of discovering that they are sisters through a donor conception process, which they discovered as adults. That chapter is a really important grounding in the book for the impact of identity in a really real and moving way. And we're most grateful to Fiona and Kathleen for having the courage to share that so publicly in this particular book. Next slide, please. The next chapters are, well, you're going to be also hearing from Laura tonight, but her and her colleague Esther wrote on international adoption and cross-border placement of children. Michael Wells Greco wrote on surrogacy and identity issues, probably an area where identity is really quite well foregrounded, unlike some of the other chapters where it's not so prominent. Marilyn and I wrote a chapter looking at identity issues in relation to relocation and international child abduction. Two Australian colleagues, Amy and Judy Cashmore in Sydney, wrote on care and protection, and Marielle Bruning in the Netherlands wrote on violence and the child's sense of identity. Two English legal practitioners, Salima and Carolina, wrote on forced marriage, child brides, and forced religious conversions of women and girls. Next slide, please. Claire Fenton Glynn from Melbourne wrote on children's right to gender identity, another really topical issue. Ursula Kilkelly from Cork University wrote on children's rights and the justice system, and particularly looked at issues to do with the detention of young people in custody and detention centres. Carabo and Fortunate from South Africa wrote on unaccompanied migrant children, including trafficked children and asylum seekers. And Nazia and Helen from the UK wrote on the issue of parental deportation and this femigration perspective, which really nicely encompasses what we are arguing for in relation to other areas of law, taking account of child identity and applying some of the family law principles to that parental deportation context. Mark Drumble from the US wrote on child soldiers, and John, who you'll be hearing from shortly, wrote a fantastic closing chapter for the book looking at the evolving scope of international transformations of children. So you can see that hopefully that gives you a little idea and picture of the type of transformations and life-altering experiences that we're talking about that children may well experience in their childhoods and adolescence, and in which we consider identity to be such a fundamental issue that needs to be better addressed by the family law system. So next slide, please. We've used this concept in chapter 1 around this idea of the family law veil. And what we are arguing for here is that there's really two approaches that are needed. We think that the veil needs to be lifted in family law proceedings to take much better account of identity becoming visible and relevant within its welfare-based sphere. So while we are very good at thinking about things to do with best interests and welfare, we're arguing that identity should be a much stronger component or element of those assessment and decision-making processes. And then we're also arguing that we need to unveil family law so that the very helpful principles and welfare considerations that are widely applicable in family law are shared with and taken on board by related fields of law, like education, immigration, and as I explained in relation to Nazia and Helen's chapter, looking at that famigration approach is a really good example of how that can happen. The asylum area is also another area where there can be an enhanced assessment and decision-making process by incorporating issues to do with identity and family law values and proceedings in those areas as well. So next slide, please. So what we're really advocating for is changes in thinking, practice, and legal policy. We want to see a fuller implementation of Article 8 so that its scope is truly reaching its potential, and a much greater emphasis within Article 8 on the impact of many life events and transformations that children experience. And we'd really like to see the book raising awareness about the broader meaning and importance of identity in family law and related fields. Next slide, please. So we've got a range of recommendations that we cover off in chapter 1 of the book. We'd really like to see the CRC committee giving serious consideration to developing a specific general comment on Article 8. I think that's sadly lacking in the area, and it would be great to see some impetus in that arena. We'd like to see Article 8 more extensively considered in relation to the other articles that Marilyn mentioned, 3, 5, 7, 11, and 12, because, you know, the synergy between Article 8 and those articles can really be for the benefit of children and young people. I've talked about lifting the veil and unveiling the family law veil. We'd like to see consideration given to incorporating identity and child-related statutory enactments in relevant legislation within particular jurisdictions. We don't see that as essential, though. We actually have it here in New Zealand. Identity is one of the factors that we have in our welfare list in relation to judges determining what's in a child's welfare and best interests. But even in my own country, it's actually very narrowly construed at the moment in relation to cultural identity of our Indigenous Maori children. So there's great scope even in New Zealand, and hopefully in other countries too, for identity to be much more visible within that welfare assessment and decision-making process. Marilyn's mentioned that we'd like to see the teaching of family law and other education and training opportunities for family justice professionals to be focusing on identity issues. And of course, as researchers, to also see a greater undertaking of legal and interdisciplinary research on the impact of life events and transformations on children's identity and the significance of Article 8, taking on board some of what Soroya has said in chapter 2 about the need for much greater research in particular jurisdictions around the world on Article 8. And the final slide, please. So just a final reflection. Marilyn and I have just loved this quote from the moment we first saw it on the CHIP website, actually. I think it's one of your members, Maya, who has made this really classic observation that the right to identity is so obvious, it's in front of our noses, yet we almost don't see it. And so we really have to make an effort to reflect on it and to realise that it is present in almost all the issues we deal with. I think that's so true, and we really, really hope that the book provides the impetus for change to be happening in this area and identity to be taken so much more seriously than what it currently is. Thank you.
Thank you so much to both of you, Nicola and Marilyn. The only thing that I can say that I can't wait when I can read the books. It's really so important, and I'm sure it will help all of us to see properly what the notion of identity actually means for children and generally for all of us. I just wanted to, on a very personal basis, highlight what I wouldn't say that it's most important, but this is what I for myself indicated in your presentation. First of all, that we used to look at the concept of identity, if we look at it at all properly, through in-connected lens, if to use author's expression. But actually, everything is connected, and this is a very important message, because in identity, everything is linked to very different elements, and it's absolutely impossible to disconnect it. And another important point for me, because I'm in a bit involved in migration issues, mostly related to Russian-speaking children moving from Russia and Ukraine, that link that is shown in the book between relocation, international child abduction, and migration, to put aside all the differences, all the differences in the circumstances. For the child, it may create similar problems, because to put aside family situations, they are all different, but the child is taken from the child's normal or usual environment and separated from many things, many dear friends, family members, and placed to some other environment, perhaps very good, but for the child, it would take time to adjust or not to adjust. So I will stop here, and let me give the floor to our next speaker, Kathleen Pithouse Morgan, who is a psychologist, from England. And Kathleen, you will be alone, not without Fiona, as I understand. But another author is a psychologist from Australia, Fiona Darroch. So Kathleen, the floor is yours. Thank you.
Hello, everyone, and thank you for being here. Just to clarify, I'm not actually a psychologist. I'm an education professor. Fiona, my sister, is the psychologist. Thank you for that introduction, Olga. My name is Kathleen Pithouse Morgan, and I'm presenting today on behalf of myself and my sister, Fiona Darroch. And our presentation is based on our chapter titled Discovering Our Donor Conception as Adults, a Sister's Selfhood Dialogue. Fiona and I live on different continents, and to this day we have not yet met in person. We came to know each other through DNA testing, which revealed that we share the same genetic father. And this discovery changed both our lives. We each discovered in adulthood that we are donor conceived. In other words, the fathers who raised us are not our genetic fathers. And although our legal identities stayed the same, our sense of self, our memories, our understanding of family were all profoundly changed. We experienced grief, disorientation, and eventually connection with each other and other new family members. So why are we sharing this deeply personal story? because our experience reflects a growing reality for people around the world. Many, like us, are discovering as adults that they are donor conceived. And this raises significant emotional, ethical, and legal questions. Stories like ours highlight why identity matters and why family law must place children's rights and well-being at the center. So just to put our story into context, donor conception has a long history. The first recorded use of donor sperm to achieve pregnancy was in the 1790s in the UK. And through the 20th century, the use of donated sperm and eggs and later surrogacy became more widespread. For many years, secrecy was standard. Donors were anonymous, and parents were often advised not to tell their children. Things began to shift with the rise of direct-to-consumer DNA testing and online support networks. Now, donor-conceived people are speaking out, connecting with one another, and demanding access to information about their genetic origins. Some countries like Sweden, the UK, New Zealand, and Australia have begun to change laws to allow access to donor identities. But this shift is not universal. One of the most personally challenging parts of our story has been redefining what family means. We weren't raised together. We didn't even know the other existed. And yet, discovering each other has brought comfort, recognition, and a sense of belonging. Building new sibling relationships as adults takes effort and emotional energy, but it can be deeply meaningful. And, excuse me. Through that journey, we've also connected with other new family members, people who share our genetic ties and are becoming part of our evolving sense of family. So what does this mean in terms of the law? Well, the legal landscape varies significantly between countries. In some places, donor anonymity is still protected by law. In others, children can access identifying information once they reach a certain age. And there's an ongoing tension between the child's right to know the truth and the wishes of adults involved, which may include a desire to maintain privacy or to shield children from emotionally complicated truths. Fiona and I believe that consistent, ethical, and child-centered laws are urgently needed around the world. So what can we take from stories like ours? To donor-conceived people, you are not alone. Seek out others and share your story in safe places. And to professionals, please listen deeply, let go of assumptions, and support donor-conceived people and their families with care and openness. To families, be open early and keep the conversation going. Children have a fundamental right to know their genetic history, shared from the beginning in age-appropriate ways and revisited as they grow and are ready to understand more. This helps foster trust, belonging, and a stable sense of identity. And finally, language matters. Saying donor can feel cold or reductive. Genetic parent better reflects the significance of the connection. So in terms of what we would like to see going forward, there is a clear need for structural reform. We call for centralized donor registers, stronger regulation of the fertility industry, and legal recognition of the right to know one's genetic history from the beginning. Cross-border donor conception adds even more complexity, and so international cooperation is vital. So to end off, as sisters who discovered our donor conception as adults, Fiona and I are still learning what this means for our identities and relationships. It's a journey of grief, growth, and reconstruction. By sharing our stories, we hope to support others walking a similar path and encourage open dialogue, empathy, and legal reform. Thank you.
Thank you, Kathleen, so much. It's amazing and heartbreaking story of two sisters. I have no comments. It speaks for itself and only proves all the problems that are created by advances in biomedical science, to put it more elegantly. Our next speaker is Professor Laura Carpanetta. I'm very happy to see you. From University of Genoa, Italy. So the floor is yours. I'm very sorry. I'm terrible with timing, but it seems that we are late. How could it happen? I have no idea, but please stick to a time. Thank you.
I promise I'll be very quick. Let me just say that I'm really, really grateful to Marilyn and Nikki, because they are real pioneers and they really helped me to understand this dimension, which I didn't really understand before. And I'm also really thankful to my co-author, Esther Di Napoli. She's a very passionate researcher in children's rights, but also in life in general. So she was really helpful, and we really did this job together. Marilyn and Nikki forced me to go back to the Latin origin of identity, which is identitas, which means that identitas are the reasons why a person is as he or she is and is not somebody else. So we go back to that, and we went back to the fact that it is a multifaceted concept, but it's also dynamic, and for children this is very important. Identity changes, and for children the big problem is that frequently identity is assessed on the basis of the perceptions that adults have of their identity. It's difficult for them to express what their identity is. It's difficult also for us as adults, but for children more, and frequently is assessed for somebody else. So I worked with Esther on measures of protection. So we started from what Olga said, and the other authors said also, that it's very important to stay in the family, but we started from situations where children cannot stay in their own families. So they are facing what Marilyn and Nikki called like the life-changing event of being protected in a different way, to go out from the family, from the environmental family. And so this has a big impact on their identity, and frequently this their identity is assessed by adults, which choose the best way they should be protected by. Then we focus on the measures of protection, two of them, adoption and cross-border placement, both contemplated by the New York Convention, of course. And the New York Convention on measures of protection stressed the importance to grant continuity in a child's upbringing, and also to pay attention to the identity, the dimension of identity in choosing the best measures of protection. So we have a point of reference. The other point of reference is that we should start from the state, and so the cross-border dimension of measures of protection is not really evaluated in the New York Convention, but it has been evaluated by the Hague Conference with two conventions which we examined. What we found out is that the New York Convention, the 1993 Intercountry Adoption Convention is well done, is grounded on the principle of the New York Convention, but it has been the case law of the European Court of Human Rights mainly to evaluate the identity of the child, to grant protection to continuity of relationship and identity of the child. So perhaps some further developments should be considered with regard to adoption. We believe that adoption was one of the best measures of protection, but there are problems in severing completely the links with the former family. And when we move to cross-border placement, which is a measure of great importance today, in particular in these moments where we are facing conflicts around the world, cross-border protection has been regulated by the Hague Conference, and the European Union copied a little bit this mechanism, but luckily used it a lot, much more than in the Hague context, and was also able to develop some guidelines, not rules, unfortunately, but guidelines in the recital of the new regulation, which focus on the identity of the child, on the need to search for family member, on the need to keep the connections that the child has with a particular state. So even these very technical and also sometimes very dry mechanisms of cooperation between states are now evaluating children identity, but of course we can do more. In the field of criminal law, for example, when the situation of the child has to be assessed, the child can participate. This is a very important point of reference for us, because this happens in the criminal cases. It doesn't happen with regard to civil judicial cooperation. So we can make further progresses in this field, and I think this book is really helpful in this respect. So I really thank the editors, Marilyn and Nikki, because they have been very pioneering in this idea. Thank you very much.
Sorry, I muted myself. Thank you so much, Laura. Yes, it's all started with adoption, as we know, and amazingly, for me, for instance, with all the discussion that generally we as lawyers and the general public have with regard to abolition of the secrecy of adoption, there are still so many parents who adopted children who do not acknowledge the importance of their children knowing the truth. I personally had such discussions, and I'm really amazed. Anyway, now we move to our last speaker, John Tobin from New Zealand. Sorry, from Australia, sorry. I frankly looked into his chapter, and I found it absolutely outstanding for somehow sorting out all the complexities and all the confusion that relates to the concept of identity. So, John, the floor is yours. Thank you.
Many thanks, Olga. Thank you for those kind comments. Thank you both to Nikki and Marilyn for inviting me part of this contribution this evening. And this book, I think, is really overdue and will make a great contribution. And can I just thank Kathleen for her contributions as well? It's a very personal story, and I think that's extraordinarily courageous that you've shared that story, but really important as well. So thank you for sharing that, and also for your sister as well. I was having dinner with my family last night, and my daughter, who's in year 11 at school, was recounting an incident in her classroom, her art classroom. Two of the students, one of the students was nonverbal, wears a tail and preferred to communicate with cat noises. The other student was Claire in year 7, but now is Charlie in year 11. And they got into conversation. There was no issue about their identity at all amongst the students. They resolved it not with language, but with gestures. And it struck me that when I was thinking about that conversation, which was just happening across the kitchen, at 7 o'clock in the evening, that my experience of childhood and identity back in the 70s and 80s in a Christian Brothers Catholic school is very different to the experience of childhood that my children are living in the 21st century as well. The other point that struck me was that for young people themselves, there isn't the anxiety and concern that adults have around the way in which children identify themselves and to their peers. Clearly, there's issues around, we'll come to that in terms of bullying, but there's a much greater openness to identity in ways that we as adults may not always think is the case. And the third point that struck me was that lived experience playing out in my child's classroom very much aligns with what I see as the conception of identity under the Convention on the Rights of the Child, and particularly Article 8. This idea of being much more evolving and much more dynamic than perhaps historically we've thought about as well. So what I'd like to do in a very brief period of time, I'm conscious that people have been listening for quite a long time, is to explore how I have tried to break down what I see as identity under the Convention into 4 discrete but overlapping components. And very much this is just me thinking out loud and what I've put together in this chapter. And it's not a mathematical theorem, but I think it's one way of reconceptualizing, expanding our understanding of identity, which importantly, I think should play out into how we think about identity in the context of not just family law, but in fact, any laws and any legal systems that intersect with children and their identity at all. So there are 4 broad frameworks or categories. One is identity as being historical. 2 is identity as being an attribute or attributes. 3 is identity as experience. And 4 is identity as being self-generative. And that last point, I think, is perhaps the most controversial for adults, but perhaps the most important for those of us who work in this space as well. So number 1, identity as historical. That's probably what we're all familiar with. That goes to the very origins of Article 8, this idea of preserving a child's identity. If you dig into the drafting history, we've identified the impacts of the Argentinian delegation. And this reference you see to this idea of ensuring the preservation of a child's true legal identity, what that actually might mean. That's a really significant thing to be thinking about, not just in terms of the experience of Argentina, but also in contemporary settings now, what's happening in the conflict of Russia and Ukraine, with I think at least 19,000 children being taken across into Russia under the pretext of their welfare. In fact, many would say it was a Russification of those children in ways that strip them of their identity as Ukrainian citizens as well. Importantly, when thinking about identity here, okay, the elements historically are things that are attributed to children at birth. So their family origins, their cultural background, their religion, their nationality, their ethnicity, and their name. All those things are assigned to or identified with the child at birth. Significantly, many may be seen to be fixed, but they aren't all fixed. This is the key point I want to hold on to as well. The other point to identify here is that they were all determined by and assigned at birth by adults to a child, invariably under the notion of a child's best interest, but as you might see later on, that isn't always the ultimate outcome as well. So just flagging that, that's where most of our attention is directed. And we look at the work of the Committee on the Rights of the Child, the work that Olga was doing. Over the years, we see an expansion, I suppose, in the jurisprudence about what that requires of states. So it's things like ensuring birth registration, prohibiting anonymity of birth. So actually addressing the situation that Kathleen experienced and her sister as well. Ensuring that children have access to their genetic origins rather than being concealed over time. So we're seeing a strong push internationally to address those historical elements of a child's identity. But as we've identified in Kathleen's presentation, there's often a gap at domestic level as well. There is, of course, a problem with thinking about identity in that very narrow historical preservation sense, in that sometimes those attributes or aspects of a child's identity which were assigned by adults at birth aren't always appropriate in the longer term as well. And I'll give you one example, just a sort of conversation kickstarter. If you think about a child born with variations in their sex characteristics at birth, we have a strong insistence in most countries to say, we're kind of uncertain about that idea of ambiguity here. Let's decide the child's either a boy or a girl, male or female, and we'll determine the identity for that child at that point in time. Now, that may be done on the pretext of the child's best interest, but the evidence is increasingly telling us that that's a very sort of problematic way of thinking about a child's identity as well. So for me then, the point I want to make, I suppose, in this chapter is that the right to preserve a child's identity is the child's right, not the parent's right or other person's rights. And in fact, that preservation and entitlement can include a right to refuse and reject elements of a child's identity at a later point in time if they choose to do so as well. So it's just trying to refine what preservation might look like and maybe some of the problematic attributes that might fly from that as well. The second concept of identity identified is the idea of identity as an attribute. And this came about largely, I thought about the experience of my own children again at school. My daughter has got red hair and she was bullied ferociously for years because of the colour of her hair. She was defined by reference to her hair colour. And in fact, when you start to drill into the bullying scholarship, you find that invariably bullying is linked to quite strongly the attributes that a child is identified as having and identified as being as well. So one study I sort of dug up, just quote a young person, "They call me a tomato because I become red in the face when I exert myself. And everyone teases me for it every day and I don't have any friends at all." Another student says they call me Harry Potter because I've got glasses. Well, a girl claimed they call me a boy because my hair cut short. Now, those things, as adults, you might think they're just silly, but in fact, they become, in some ways, the most significant aspects of a child's life, and they become elements that define their social identity in ways that often aren't particularly helpful at all. So the idea of identity as an attribute is used to explain the way in which the identity of a child is defined or influenced by reference to a child's personal characteristics and or preferences, either by themselves or by their peers. It's important as well. So maybe not something they want to be identified as being, but socially, that's how they're defined as well. So it will include their sex, their sexual orientation, but it could also include things like their body type, their physical appearance, their hair color, their intellect, their physical size, and their physical abilities as well. All the things that perhaps many of us would have experienced back in childhood and hopefully never do us now, but it was part of the experience we often had as well. Now, the point about this, of course, is that these attributes aren't things that are identified in the convention, not the list as protected attributes under the convention at all. And of course, some can be positive things. So a sporting ability of a child, their height, etc., may be positive aspects of a child's identity, but in many cases, they can play it to be very, very harmful as well. So the key point here, I suppose, is that preservation of identity here doesn't mean a lot to a young person, okay? What matters is, are we protecting and promoting them against discrimination because of their perceived identity within their own social settings as well. So it's a different way of thinking about identity, how we ensure that young person is taken care of. It becomes more complex when we start thinking about, well, do we actually want to ameliorate the circumstances that give rise to that disability, so that definition of ability as well in the first place? And that sort of linked to broader conversations about things like the impact of plastic surgery for children who identify in ways they want to change their physical appearances, and then the impact then of things like social media. So it's a broader conversation. So we're stretching ourselves out of identity in family law around things like relocation or family breakdown. Now we're saying, when it comes to things like how we regulate social media, are we looking to impose regulations around the way in which that will impact and shape a person's sense of self and who they are, how they may deal with their own physical appearance as well. So the third conception of identity identified is identity as experience. Really what I'm doing here is I'm drawing on the idea that experience itself will refer to the way in which the experience of a child can be used to define that child and, importantly, their status in society and the way they are treated. This happens all the time in terms of how we label certain groups of children: street children, child labourers, child soldiers, refugee children, child brides. Now, invariably, those labels are used to define children, identified children, who often sometimes will in fact require special treatment under the convention, and the motivations were benevolent. We want to provide additional care assistance for those children. So the intentions are in fact positive. The challenge, of course, is though when we do that, invariably the motivations are underpinned by a welfarist agenda. Now, not in sort of saying that's a bad approach, but it can be harmful in how we think about young people in those contexts as well. So whilst the convention imposes obligation to assist and enable groups that are particularly vulnerable, we don't want to define them by their vulnerability, if that makes sense. So certainly experience becomes a critical part of who they are as human beings, being a refugee child, being a child who may be in a forced marriage, being a child who experiences child labour, exploitative conditions, or a child who experiences armed conflict, are all significant parts of who they are and their identity. That will become relevant in a whole range of contexts, but we don't want to define them by reference to that particular experience as well. So what you see the committee doing, I imagine ultimately part of this conversation, is we see then a great awareness of the need to avoid defining a child by their experience, but recognizing the experience on that child's identity. For example, rather than a child being a street child, it's a child associated with street situations. Rather than being a child in armed conflict, it's a child associated with armed conflict. So we're seeing a great awareness of the dangers when we associate the identity of a child with their experience as well. So it just requires more reflection on the part of policymakers, of advocates and NGOs about how we engage with and deal with children as well. Now, the last idea of identity is as a self-generative. In many respects, this is probably the one that will scare adults the most, but in fact is perhaps the most important part of the conversation in any context, whether it's family law, whether it's schools, whatever it might be as well, whether it's me as a parent educating and looking after 4 children. So here we're talking about this idea of identity as being an evolving and transformative understanding of that right. So rather than being fixed, okay, rather than being defined by what others say about you, rather than being defined by how you experience life, it's about how the child, him, her, or themselves go about defining their identity over a period of time as they evolve with their maturity as well. So children here become the authors and creators of their own sense of identity. Now, this is the idea that, of course, is consistent with how all of us see the Convention on the Rights of the Child. This idea that over time, a child's evolving capacities allows them to exert greater influence on their own sense of self and informing their understanding of the rights. So we take Article 12, this idea that you are required to ensure that a child can express their views on all matters concerning them must, by definition, also extend to their sense of who they are and their identity under Article 8 of the Convention as well. So really, is it radical? Certainly, yes, it is. Very, very radical, confronting for adults, okay? But it clearly has to align with what the Convention sees is a sense of a child's identity. The greatest example of how this plays out right now, in some respects, is the issue of transgender care for children. It's happening all around the world right now. Donald Trump has, like many others, had this strong view that there are only 2 sexes, male and a female. You're born that way. It stays that way forever. The reality is that if you speak to people working with young people who are seeking to transition and affirm their gender, it's a much more complex conversation than we might give them credit for as well. So under a rights-based approach, it's really important to recognise that children, firstly, identity is fluid, and secondly, that children themselves have an authority and a role to play in developing their own sense of identity over time in line with their evolving capacities as well. So to wrap it up, because I'm conscious you've been listening for a long time, identity, certainly under convention for me, is a multi-layered, but also an evolving concept as well. A great book I came across, which I encourage you to all read, is called Who Am I by Philip Bunting. It's a children's picture book. And like most children's picture books, it captures the complexity of the conversations we're having tonight. You have a young child asking a whole range of questions, and it sort of asks, I have a name, but it doesn't define me. And the key argument from the book is really that just because you have a name or you have a nationality, that doesn't define who you are as a child. The ultimate question, or the ultimate one which it ends the book, is that who you choose to be in this lifetime is up to you. Bottom line is young people have this right to have authority over their sense of self. So in that way, we see identity as being this really dynamic and evolving concept, which consists of a constellation of elements where children become the central protagonist rather than a peripheral player in understanding their own identity. And I'll finish there. Thanks very much for your time and patience. And apologies, I'm coming off a nasty cold, so my voice is probably less discernible than otherwise would be the case. But thank you for listening and thank you for your time.
Olga, just to
Sorry.
let
Yes, I'm sorry. Thank you, John. Thank you so much. Actually, John gave us a kind of a roadmap for our future work. And we are definitely, thanks to that book, we now more or less equipped with lots of thoughts and perhaps even prospective decisions of complicated issues, but we are definitely in the beginning of this interesting journey. As I understand now, we have time. Surprisingly, we are doing well with timing. We now have questions, and I have one question in the box, which is addressed to Professor Marilyn Freeman. It says, in Cambodia, children have emphasized that justice cannot be equated with financial compensation. They have also shared that the local mechanisms are ineffective, especially when perpetrators are powerful. How can international family law better uphold and protect children's identity and dignity in such contexts, particularly where non-judicial pathways are weak or inaccessible? Marilyn,
Yeah,
the question to you.
it is the question to me from Sam Venn. So thank you, Sam Venn, for the question. It's very sad to hear that that children are saying that local mechanisms are ineffective and that they're subject to the power of perpetrators. Sad, but not entirely surprising. My suggestions really are, I don't know how helpful they are, but I would say awareness raising and advocacy are the ways that we can produce the greatest impact. What you're describing is a problem which I don't think is limited to Cambodia, and it be difficult. I mean, it's obviously brings into play political considerations, which are not anything that I can really that I can really offer much comfort with. But I do know that awareness is an important tool in any fight. And so awareness raising and advocacy, I think, are the elements that we need to focus on. Hopefully, this book, others which may follow, work that's being done by Chip and other people around the world, hopefully these will lead to a more of a recognition and a normalization of identity being the right that it is, that children should be able to rely on in its broadest context. So although Sam Venn, I don't know how helpful that is, it's probably the most realistic response that I can give you. I hope that's of some use, but I'd be pleased to hear what you think about that as a route.
Thank you, Mia. Oh, thank you, Marilyn. Mia is sending me messages with some instructions. I'm sorry. So thank you, Marilyn. But there is another question to John from Lena Opferman. Thank you for the very interesting presentations. What was the name of the author of the children's book on identity that John Tobin just mentioned?
Yeah, thank you, Olga. The author is Philip Bunting. Philip Bunting. Just Google it, it'll come up. It's about $15, I think, on Amazon.
Mia asked the floor to add something regarding to the questions raised. Mia, are you here?
Yeah, I am. Thanks. I just wanted to also build on Marilyn's answer that she responded to. I saw that, Sam, you're also working on the general comment, number 27 from the CRC committee. If you know, I will put it in the chat function, but the draft general comment has just come out and it's open for comment for the 30th of June. But in terms of what you're saying, it's true that it's not just limited to compensation, but they've also highlighted 3 other areas that states have responsibilities to in terms of access to justice. And one is in terms of restitution. So in terms of identity, this would be including speedy re-establishment of the child's identity. So states have that obligation. It's not financial. The second area is in terms of recovery and reintegration. So if we're looking at past abuses, this could be unmarked graves, access to records for children that are in care. There are a number of things that you could look at. And then the last area in terms of access to justice is the state's obligation for non-repetition. So they need to do institutional reforms to make sure that the human rights violations, including in family law, are not repeated. But I will share that link to the general comment. It's already very insightful. It will change, but it already gives you on the last 2 or 3 pages these 4 areas that states are obliged to respond to when there's a human rights violation. Thanks.
Thank you, Mia. There is another question to Nicola Taylor and Marilyn Freeman. In many European countries, after the immediate return of the abducted child, there are serious restrictions on contact with the abducting parent. Recently, a court ruled that the mother could only speak to the child in the language of the country, oh my goodness, which in practice made these visits impossible. This ruling is common in European countries. How can we convince these countries that identity rights are being disrespected? This is a question from Rodriga Meira, if I pronounce correctly. Yeah, but this is what we are talking about. So
I can start off and perhaps I can piggyback with Nikki on this, but hi, Rodrigo. It's yes. What can we say about that? Is that ruling common in European countries? You may know more about that than I do, but obviously when there is a decision to be taken about contact or access, whatever we want to call it now, if there's a decision to be taken about it, most countries will take that decision in the best interest of the child, and they will apply their own criteria to what amounts to the best interest of the child. As we know, an indeterminate concept. The best interest of the child means different things to different people. One of the things that we have been arguing in more generally and in this book specifically is that in determining best interests, in looking at a welfare checklist or whatever the elements are which the court takes into account in determining best interests, that identity should be one of the factors that is at the center of the court's consideration. So whatever else they consider in terms of what amounts to the child's best interest in relation to, in this case, whether the child should have contact with the abducting parent, the impact of the decision that is being made in the best interest of the child, the impact on the child's identity, we argue should be one of the factors that the court considers. So how can we convince these countries that identity rights are being disrespected? Well, as Nikki said during her presentation, we would like to see, but we don't think it's necessarily, we don't think it's compulsory to do this, but we'd like to see identity being formally included in the welfare checklists which are applied in best interest decision making. But we don't think that that's absolutely essential, because there is scope within most best interest decision taking structures for identity to be included. Again, in the way that I spoke previously about how do we do this, we need to raise awareness. We need to advocate, we need to raise awareness, and we need this to become normalized, that identity is not out on the periphery. It's not something that is sort of, vaguely interesting and, something that we don't really understand. It's up there, it's central, it's who we are. It's what Charles Taylor said. It's our horizon. It's imperative that we include identity in welfare decision-making processes. Nikki, I'm sorry. Is there something else to add to that?
I agree completely with what you've said, Marilyn. That's exactly what I would have said, Rodrigo, as well. The only other suggestions I can make is that it comes down to this attitudinal issue, which is linked to the awareness raising that Marilyn's talking about. And so I would very much suggest that the Permanent Bureau at the Hague Conference on Private International Law should, this should be drawn to their attention, and also to the attention of the Hague network of judges, because it's really, really important that they start factoring identity issues into their decision making and into the evidence and the assessments that are being brought to their attention in particular individual cases. So I think there are some things that we can do, but it's a matter of awareness raising and advocacy, and making people, in professional decision-making roles far more aware of the significance of identity issues for children, and why they need to be taken into account in a much more explicit fashion than what they currently are. Thanks for your question.
Thank you for answering these questions. As there are no questions in the box, I would like to ask all of you, what in your opinion would be the most important recommendations that we can make to the states in order to better respect the child right to identity, and also link to that in order to provide the child with opportunity to protect his or her right in case it was violated, meaning access to justice. Thank you. Just the key thoughts. It's a huge topic.
Maybe let's start with John, Olga, and then go backwards. Laura, and then Kathleen, and then Marilyn and Nicola to finish.
No, I don't want to let them decide if John wants to start.
That's fine, Olga. So two comments. I think one, it's the theme of tonight. It's that we have to encourage states to treat the right to identity as being a serious right. I think it's very much on the margins. It's not explicitly included in the European Convention. That makes it harder, I think, in terms of that jurisdiction leading the way. So that's the first and obvious point. The other point as well is for advocates to be more, I suppose, creative in how we can interconnect the right to identity into existing frameworks, either regional or domestic levels. So the right to respect for private life, for me, becomes a point we can start to expand that idea with the sort of conversations we've been having about the scope and meaning of the right to identity as well. So part of it's about convincing not just states, but also our colleagues who are policymakers, advocates, lawyers, working in these spaces to treat it seriously in their own work and look for hooks to bring it into conversations that might be able to shape the way in which cases are argued or policies are drafted as well. So that'd be my two comments.
Do you want to add anything, or it's more or less explicit? I fully agree with John.
Yeah, I want to add something about the method. I think children should participate in this assessment of identity, and it's difficult to say how, because it's difficult also for us to say what is our identity. So it's the method is not easy, and also for children, I think it changes so quickly that you really have to figure out a method which allows you to assess it on a regular basis, what is the identity of the child, if you need to, like in measures of protection. I was thinking about my field. Thank you.
Sure. Thank you, Laura. As we still have some minutes and we don't have other questions, I have...
No, Olga, you need to let Kathleen speak and...
Sorry.
Yeah, Marilyn.
Yes, of course. I didn't see. I'm sorry.
Thank you, Olga. So I would just want to repeat really our key message, which is that children have a fundamental right to know their genetic history. and their genetic family shared from the beginning in age-appropriate ways and revisited
Yes.
as they grow and are ready to understand more. Thank
Yes.
you.
Thank you. Marilyn or Nicola? Or
Nikki,
Uh,
do you want to go?
no. So my questions, I have a provocative question to which I myself don't have answer.
Mm.
At what age the child should be allowed to get access to information on origin? The committee is silent on that. It speaks just about that the state should provide the child with access to information. In one of the concluding observation, it states that the child should be provided with the psychological counseling. From that, we can assume that the child should be not at least a newborn. Otherwise, counseling doesn't make sense. But in principle, the child should have this right from the birth. So how to coincide these tricky dilemmas? If you have any thoughts, well, we can leave it for future.
I think Kathleen might have some very relevant thoughts on that, having discovered very painfully in adult life about your origins. I don't know whether you have any thoughts on when it would be right to.
I think, like every person, you know, we need to know who we are right from the beginning before we can talk. Our
Yeah.
parents or the people who are taking care of us need to be telling us age-appropriate stories about who we are, and so that it never comes as a shock.
The earlier the better, as psychologists assured us.
Yeah.
And
Can I just say, I agree with that. I think that's the key point. So the evidence tells us that the earlier a child knows about their identity in any context, then the healthier they will be in terms of their self. So that sort of tells us the answer to the question, right? So that's how do we create regulatory environments that essentially not force or coerce, but really encourage parents to ensure that they provide information to children at that much earlier age in an age-appropriate way. So the colleagues I know, where they've used genetic donors to provide and assist with childbirth, have had very early conversations, 2, 3, 4, 5-year-olds, about that process. And I'm assuming that can only be a positive thing as well. So I think it's about shifting not so much what number, is it 12, is it 13, because that becomes complex, but it's about how we change the entire culture, about how we think about the way in which children are conceived as well. And Kathleen's experience tells us that it ain't great if you ain't told until you're an adult. So there's no point having rules that say they can find out when they're 18. That's 18 years you've lived of a life which hasn't been as complete as it should be as well. So we've got to really shift it right back to let's have the confidence to share those stories about in an honest, transparent way at the earliest age possible.
And maybe if I can also jump in one more time, very important access to origins. Of course, child identity protection is pushing for that. But in terms of assisted reproductive technology, we're also pushing for it to be done in a way that respects human dignity. Because what if the child knows about the way they were conceived, but it's in a way that they wouldn't be proud of, that they wouldn't be happy to tell their friends at school that I was conceived from a gamete from a person that was deceased, or I was conceived from a serial donor who had got 1,000 other siblings that I can never, ever get to know. So I think it's making sure that the right to identity has its place, the same place as every other right. At the moment, the right to identity is very much forgotten, but it needs to be human dignity, best interest of the child, all the non-discrimination that you talked about. But I had to say that because this is what we're pushing with the Council of Europe as they do their work on this new recommendation that they're drafting on access to origins. We've told them it's not just about access to origins. Identity is also being proud of your identity.
yes, Mia, fully agree. But we will inevitably have to go further, trying to answer the question, who are gamete donors? Are they parents? Are they family members? Are they still strangers? But this lots of things to think through. We still have some few minutes. If you have some final comments, wishes, questions, you're welcome.
Just perhaps one issue to raise is around our call for a general comment by the UN Committee on the Rights of the Child on Article 8. Obviously, Marilyn, in my view, and some of the authors in the book that comment on this as well, is that it would be incredibly helpful to have the scope and considerations to be taken into account in relation to Article 8 to be articulated more fully by the committee. And I can see Mia nodding, so I'm sure that this is something Chip is pushing for as well. I mean, Olga, in your capacity as a former member of the committee, how realistic and likely is it that a general comment on Article 8 could be produced?
Well, with general comment is always unpredictable. It's relatively slow progress, generally, I mean, working on the general comment. But taking into account the importance and attention to the issues of identity now, I would be positive. It also depends on what are the competing proposals, which I'm not aware, perhaps Mia knows. But for me, definitely this would be number one. And by the way, I would link right to development, right to identity, also to the right of development under Article 6, because it is all about development. And it says that states parties shall ensure to the maximum extent possible development of the child. All issues related to identity fall within, it's about development.
Yeah.
So Mia, probably the floor is yours.
Okay, thanks for that, everyone. Fantastic presentations, and thank you for these excellent questions. I saw that quite a few are about access to justice. I've been quietly pushing or advocating for Nikki and Marilyn to take up a volume 2 of this fantastic publication on access to justice. So in terms of when a child is a child bride or in armed conflict, what kind of access to justice, especially when their identity rights have not been respected. So let's see, hopefully we can work on something like that. In terms of the CRC committee, some bad and good news is that given that there is this UN liquidity crisis that's happening as we speak, the upcoming session of the committee in September has been cancelled. And so they will have their next meeting maybe in January. And it's all up in there depending on the liquidity crisis. But on a good note, I did have a meeting with about 4 or 5 members 2 weeks ago, and they have indicated their interest in a general comment on identity. So it's all about now and they were the newer members, because there are some existing members that are already in agreement with that. So it's about now getting more people working with the 18 members to convince them that this has to be the next topic. But as Olga mentioned, there are other competing issues. But we will be having a meeting with the committee, a briefing session with them when they meet next. So hopefully we'll convince them. And that will be with UNICEF, UNHCR, ATD, Fourth World, some other organisations working on this topic. So thank you, everybody. We will be sharing the recording with all the people that have registered. I also saw that Marilyn Crawshaw has noted that the links, you can't open them, but we will share all of that in a email to everybody. Thank you for your participation today. Thank you for the fantastic speakers, especially Nikki and John, because it's quite late for you in the Southern Hemisphere. And we look forward to working with you all to make sure that this right to identity is better protected in the future. Thanks, everyone.
Thank you.
Bye.
Thank you very much.